We're here in a matter of Gene Hausmann versus Langen Realty et al. 45 CO1 1111 PL 156. For the record, everybody identify themselves and who they're representing.
Attorney Joseph Svetnoff on behalf of Gene Hausmann as a trustee of the Marsh Assured Trust, and I have on the side of me Gene Hausmann, trustee.
Attorney Gregory Brown for Langen Realty, James Langen, and William Langen, Your Honor.
Okay. And what are we here on this morning?
Judge, this is set for a defendant's motion for summary judgment, and we argued a motion to compel and motion for leave to reopen discovery last Tuesday. Judge,
there's no ruling on that.
No ruling on that, and that's kind of intertwined with what is alleged in defendant's response to our motion for summary judgment.
Right. Well, why should discovery be reopened?
Well, we filed our motion for summary judgment based upon the plaintiff's answers to interrogatories, where the trust stated that the promissory note, which is what this claim is based on, the promissory note in issue spoke for itself, and there were no additional witnesses other than those contained in the promissory note. So you look at the promissory note, Langen Realty's corporate officer signed the promissory note, and no other witnesses. So we took that to mean that there weren't any witnesses other than my client and his corporate entity, because the trust is an entity with just a trustee that wasn't there. The trustee wasn't present at the time the note was signed. So in their response to our motion for summary judgment, they filed an affidavit by the trustee saying that there were representations made by my clients to the trustee, this trustee, Marsh Assured. And we asked to take her deposition to see what those representations were. At first we didn't receive a response, just that they didn't want to produce her. And then after I filed my motion to compel, they raised the issue that discovery was closed. So that's kind of where we're at. We filed the motion to compel and the motion to reopen discovery, specifically to depose Marsh Assured as the trustee.
Your Honor, in response, when we actually answered the interrogatory questions, the interrogatory answers were based upon not only the promissory note but the complaint, which spoke for itself. At the time, Your Honor, we filed the complaint. We filed on behalf of the trust and on behalf of the trustee, Gene Hausmann. It's been no secret, it's been no mystery who the plaintiff is, has been in the case the entire time, and who the complaint was filed on behalf of the entire time. As well as the promissory note, when it was entered into in 1992, was entered into by the trust itself. This is the successor trustee to the trust, and Your Honor, we have had discovery closed for 5 months now. To have discovery reopened because of...
Where's the answer to the interrogatory?
That's Exhibit 2.
Yeah,
attached.
which one?
Oh, let's see. Answer number 4. I asked for all the terms of the alleged oral contract between the plaintiff and James Langen, and the answer is the terms of the promissory note speak for themselves. And then the last sentence, please refer to the promissory note, which would identify witnesses as to any and all contracts between the parties. So they've identified no witnesses, especially the trustee, who now they allege my clients made representations to. So I'm asking just for the facts, Judge.
Is that true?
Your Honor, we've identified the promissory note in the complaint.
I mean, but what did your affidavit say?
Your Honor, it was based upon the knowledge of the trustee, successor trustee, Gene Hausmann, who has been named as the...
What knowledge is that?
Your Honor, having to do with her knowledge of the actual promissory note, the payments thereof, the breaches by not only Langen Realty, but also their individual officers, James and William Langen.
So all she did was collect the money? Is that what?
Well, Your Honor, I mean, she's the trustee. She runs, I mean, she has the sole duty of managing the trust, not only collecting monies, filing suit on behalf of the actual trust itself, and procuring anything that belongs.
What do you expect to get from her?
Well, they've alleged fraud, and they've got to prove fraud, and they're alleging through her that my clients made fraudulent representations specifically to her. And they've alleged breach of contract, of an oral contract, aside from the promissory note that was filed in this case. And they've alleged in her affidavit that my clients made oral representations specifically to this witness about making an oral contract with the trust. But they didn't disclose her in the answers to the interrogatories. I asked specific questions about what oral representations were made by whom, and no witness was disclosed. You simply say, see the complaint, which doesn't talk about any witnesses, and see the promissory note, which doesn't talk about any witnesses.
Your Honor, interestingly enough, the complaint, when it was filed by Gene Hausmann on behalf of the trust. Your Honor, any and all allegations throughout the complaint were based upon the successor trustee, Gene Hausmann. It's no secret that Gene Hausmann is the sole witness regarding this litigation matter. This is not litigation by surprise, Your Honor. This matter was filed back in November of 2011.
You completed all your discovery?
What? I guess that...
Nobody's really done any discovery other than my interrogatory.
No, Your Honor, we've done discovery.
There's been no depositions.
Well, no, there's been paper discovery done.
Have you completed all yours?
Well, Your Honor, I guess that's a potentially. And it's based upon, I guess, your ruling here today on his motion for leave to compel further discovery 5 months after the discovery deadline closed.
Judge, you asked about her affidavit. She says in her affidavit that the parties mutually agreed to all terms concerning monetary payments and through a continued oral agreement. So she's alleging she has personal knowledge of some oral agreement.
And when did you get that answer to that interrogatory? The affidavit?
The affidavit, March 28th.
After the close of discovery?
Right.
All right, we'll open discovery for 30 days.
And then continue the summary judgment hearing until after.
Yeah.
Your Honor, I would suggest opening up 45 days.
45?
45 days, so if we're going to, I guess, open up discovery, we're going to have to open it up on both ends.
Okay. All right, give me 45 days out. Let's see, that'd be, it's June 24th today.
Yes.
But August 14th. Okay.
That's fine. Thank you, Your Honor.
And then let me get you another, have you filed a response to the summary judgment? No?
Yes, we did, Your Honor.
All right, well, I better, there may be more dispositive motions pending this.
Can we get a time period to supplement our motion for summary judgment? And they can.
Mr. Svetnov might want to file one too.
Right.
Oh, definitely, Your Honor.
How about September 18th for dispositive motion cutoff date? 30 days after the close of discovery. And ask Dickie for a date in October for
Hearing.
Oh, wait. I guess,
Probably being in November, right?
yeah, because you're gonna file responses and all
A
that.
reply.
November, Rich. November. Yeah.
Oh. No, Your Honor, now, that will be set for a motion for summary judgment hearing and potential cross motion, and also a damage hearing, Your Honor.
Well, if, I guess you got a ruling on one summary judgment for it.
Right. Right.
Do we have a ruling on this case already?
Well, Your Honor, we have a partial summary judgment ruling as to liability for Langen Realty corporate entity.
On the promissory note,
On the promissory.
but not a monetary amount entered.
That's why we need the damage. That's why we
damage hearing too?
I think after the summary judgment hearing, there should be a damage hearing.
Why don't we set it for, why don't we do it with that? Nothing? December.
Friday, December 6th.
December 6th, 10 o'clock.
That's fine.
And we'll set everything for that day. If I rule on the summary judgments, then we'll go forward with the damage. Okay?
Very good, Judge.
Thank you, Your Honor.
Thank you.
Yeah, I told him that, by noon, we'd probably have it back downstairs.